Okay, I just pressed the button for this to go live on YouTube. Good morning, everyone. My name is Brad Gardner. I'm going to be presiding over this morning's pre-issuance hearing calendar. I'm going to call the calendar first to see where we are, and then I'm going to give some further instructions. So pay attention, please. I have position number 1 is Vernon Fowler versus Kawan Clark.
Your Honor, both parties are present. And then for Clark, he has an attorney representing him, Attorney Joyner.
What's the lawyer's name?
Joyner.
Joyner. Okay.
Maurice, what's the attorney Joyner's first name?
Sean Joyner.
Sean Joyner, okay.
Yes, ma'am. And Joe Todd is representing the petition.
Hi, Mr. Todd, how are you?
Good. How are you doing this morning? I represent Stephanie Stevens and Vernon Fowler.
Okay.
Okay.
Did you get that, Judge?
Yes, Mr. Todd is representing Mr. Fowler and Miss Stevens. Okay. And Mr. Joyner is representing Mr. Clark on both cases.
Yes, Your Honor.
Thank you. Position
Judge, I was just going to say, I don't know if you want to take it or not. Mr. Joyner's got a motion to make. So I don't know if you want to take that up now or take that after you call the calendar.
Okay. Position 3 is Mia Garzindine versus Cedric Moten, sorry.
Your Honor, the plaintiff is here and she also has a witness outside the courtroom,
Okay.
but the defendant is absent.
Okay. And I'll take it up when we get to that case, but I do have a question about whether jurisdiction is appropriate in this court. Position number 4 is Mia Garzindine versus Ernest Williams.
Your Honor, both parties are present and Miss Mealy, the defendant, she has a witness, the same witness for the other case. And then Ernest Williams have a witness outside.
Okay. And is this the case where they wanted to have a discussion about mediation?
Yes, sir.
Okay. Position 5, Brandon Sewell versus Kimberly Hardiman. We have any party?
Your Honor, we have some people just came in the courtroom. May I be excused for 30 seconds?
Yes.
Thank you. For those Thank you, Your Honor. You can proceed, Your Honor.
Okay, do we have an announcement for Brandon Sewell versus Kimberly Hardeman?
Yes, Your Honor, Ms. Kimberly is present. The defendant
Is,
the plaintiff is absent.
okay. Mr. Sewell, if you need to make an announcement, you need to make your announcement now, or this case will be dismissed for warrant of prosecution. Hearing no announcement, this case is dismissed for warrant of prosecution. Ms. Hardeman can be excused.
Okay, thank you, Judge.
You're welcome. Position 6, Yolanda Kent versus Brandon Watley. Do we have an announcement on this case?
Your Honor, both parties are absent.
Okay. Ms. Kent, you need to make an audible announcement or your case will be dismissed for warrant of prosecution. All right, hearing no announcement, this case is dismissed for warrant of prosecution. Position 7 is Tessa Drayton versus Kenneth Green.
Your Honor, both parties are present.
Okay. Position 8 is Jaleel Hutchins versus, is it Whitcliffe McKay Jr.?
Yes, Your Honor, both parties are present. The plaintiff has a witness outside.
Okay. Position 9, Kimberly Cothran versus Gary Lee Lynn Jr.
Your Honor, the plaintiff is present. The defendant is absent.
Okay, we have to check service on that case.
We have not received notification back on that.
This case may have to be continued.
Okay.
Position number 10 is Chantel Connor versus Quintonio McLeod.
Your Honor, both parties are absent.
Okay. And we have the notice on this case. Chantel Connor, please make an audible announcement or your case will be dismissed for warrant of prosecution. All right, hearing no announcement, case is dismissed for warrant of prosecution. That completes my calendar. Is there anyone that's present that expected to hear their name called and their name was not called? Okay. So I have some short instructions before I'm going to get to the Clark case. And this applies to everyone, so please pay attention. This morning's calendar is here to consider applications for arrest of the accused based upon some allegation of criminal conduct. At this time, no warrant has been issued for anyone. The purpose of this hearing is to determine if there is sufficient evidence to establish probable cause for a criminal warrant to issue. If you are the applicant and have decided not to proceed, you can make that announcement and your case will be dismissed. If you are unable to resolve this matter prior to your case being called for a hearing, the court will allow both the applicant and the accused to present evidence, call and question witnesses, offer explanations for conduct or events, and propose resolutions to your conflict, including but not limited to the issuance of an arrest warrant. Before commencing testimony, I must advise both parties, especially the accused, of certain constitutional rights. The accused must be aware that the applicant is seeking a warrant for his or her arrest. Neither the applicant nor the accused can be compelled to testify. Both have the right to remain silent. No one must say or do anything that incriminates themselves or makes it appear that they are guilty of a crime. If at the appropriate time you elect to have this proceeding constitute a hearing. Should a warrant may be issued against you, you will have the opportunity to invoke your right to counsel if you choose. You must understand that if the applicant or the accused says or does anything that incriminates themselves, that information may be used against them in this hearing as well as any subsequent hearings or trials that may be the result of the findings of this court. The applicant and or accused may waive their right to remain silent and offer testimony if they choose. Everyone who testifies will be placed under oath, and once they testify, they will be subject to cross-examination by the other party, and the court may ask them questions. Anyone who is offering testimony may stop answering questions at any time and invoke their right to remain silent. However, any refusal to answer questions may result in rejection of testimony already given. Either the applicant or the accused may seek the advice of an attorney before testifying. However, the hearing will not be automatically continued while you seek legal counsel, and counsel will not automatically be appointed prior to the issuance of a warrant for those unable to afford counsel. The court will consider any request for a continuance or appointment of counsel for the accused, but may choose to proceed in the hearing today. If the accused wishes not to testify, he or she may do so without giving up the right to question or call witnesses. So that's my short statement. Now, Mr. Joyner and Mr. Todd, I understand that Mr. Todd has filed a motion.
No, yeah, Mr. Joyner filed the motion.
Good morning, Your Honor.
Good morning. What's your motion, Mr. Todd?
Look, Your Honor, it's Sean Joyner, and I don't know if Your
Oh,
Honor.
I'm sorry.
Your Honor may have it in front of you, as far as it should be in one of the files, at least.
I don't see the motion.
Yeah, I didn't see the motion either, Mr. Joyner. Did you file it with the clerk's office?
So interesting enough, yes, because the same thing happened with my conflict, and I actually filed it, and I called, we had the clerk's office call back to Judge's Chambers to see if I could bring a copy back, and they said I couldn't, and so they assured me that it would get back there, but I do have an additional copy today, just in case, but I filed it on the 9th.
All right, let me look, Judge.
Okay.
But Your Honor, in a nutshell, I can advise you, Your Honor, what it is. And then,
Yes, sir. Yes, sir.
Your Honor, this was originally, well, it was put on a January 10th calendar in which I had subpoenaed Officer Mustafa of the Clayton County Police Department. And I had legally served him. There was a attached copy of it with the motion that I filed on the legal counsel of the police department accepting it on his behalf. Mustafa was under COVID protocols and was not able to come. When he came back from that, we talked to him, and we then had this date set up for today, and then we got an email that he is in training and is not able to be here today, and that's when I filed it as soon as I found out about it to let the court know. Now, I had offered counsel that we could stipulate the police report in as Mustafa's testimony. But it's my understanding, and I don't want to put words in Mr. Todd's mouth, but that they're questioning the integrity of the police report, which I think would mean the officer would really need to be here. And we would ask for him to be here for that. And so we had filed that motion for continuance based on those purposes.
Okay. I see an incident report in the file. Naming Deborah Fowler and Kawan Clark.
Yes, Your Honor, that's the report that was filed with both petitions.
Okay. What's your position, Mr. Todd?
Good morning, Your Honor. My position is, Your Honor, we would object to any continuance. This is the fifth appearance of this case. The case has been continued 4 prior times at the request of the defendants in this case. So that's the problem, Judge. This is now the 5th time that my clients, I have not been here all those times. I've recently got involved in the case, but my clients have been here 4 separate times previously, and the defense has requested continuances 4 different times prior to today. So that's the problem, Judge. If this was the first time, I would definitely agree, and I would agree to continuance. That wouldn't be any problem. But this is the 5th time now my clients have been here, Judge, and all 4 times it's been continued at the request of the defendant. So therefore, as a result of that, Judge, we must object to the continuance. Furthermore, this case was the last time was continued for the officer's reason, and this was set specifically for today because of that. So they had the case come up the last time. It was specifically set for today's hearing. So I don't think it would be fair, Judge, that it's been continued 4 times at the request of the defense in this case. And now we're here the 5th time. And of course, the officer he wasn't there and witnessed anything. He was called and was there after it all. Whatever happened. He got there after the fact. But be that as it may, Judge, this is the 5th appearance. So my clients have instructed me to object to that because it's not fair for them to be here 5 times and be continued 4 times at the request of the defense. They've never requested a continuance in this case.
Mr. Todd, let me ask you this question, and I'm glad that both sides have counsel here so I can ask this question. The allegations that are made in this in the narrative of the pre-issuance, I didn't see anything about law enforcement being called. I saw something about a concussion and a broken ankle. And it would seem to me that this would be something that law enforcement should be requesting a warrant, not citizens.
I believe, Judge, that the police, is my understanding, came up after the fact. So I'm not sure what they did, but they weren't there when all this took place.
Well, normally that's the case, Mr. Todd. We don't have law enforcement officers sitting out at every location where they observe what happened. Most of the time, there's a phone call made to 911. The officer comes out and the officer makes their own observations and determines whether a warrant should issue or not. So I'm assuming that happened in this case. And the biggest question in my mind would be why the law enforcement officer did not issue or seek a warrant.
Good, Judge. I think it was after the fact. So I'm not sure what his reasoning was or wasn't. So
Mr. Todd, I'm awakened at 2:30 in the morning every time I'm doing warrants, where officers are seeking warrants after they've been called to a scene and they've observed something that makes them believe that a warrant should issue. And they have the authority to call me out of my bed to listen to their testimony and to issue a warrant. So you're telling me that your client may have suffered a concussion or a broken ankle, and law enforcement came out, saw all of that evidence, and determined that a warrant should not issue?
No, Judge, I think there was a warrant issued in this case. There was other parties involved. The defendant's brother was also implicated in this. And I believe, if my understanding is correct, Judge, that there was a warrant taken out for the suspect, or there was going to be a warrant taken out for him. I'm not sure why that's all I know, Judge. Obviously, I've got involved. This is the first time I've been here on this matter. But it's my understanding that the defendant's brother was also involved in this case, and he came in a vehicle at some point in time, also was involved in this altercation. And he was, it's my understanding, either was they put a lookout for him or he did something as far as to arrest this other person. So that's my understanding of it, Judge.
Your Honor, may I expound on that just a tad to clear it
Yes,
up?
sir.
Your Honor, first of all, the latest petition on this case, the application was filed on December 7th. I don't know the 5 dates that there have been since December 7th. This is my second date appearing since I have entered in on this case. Second, the officer did show up. The officer actually, after reviewing security cameras of both the petitioner and the defendant, made the decision as far as the warrants are concerned and did seek a warrant for my client's brother. Declined a warrant both for the petitioner and for the defendant because there was a lot more to this than just what he saw on video. And that's why with the officer actually reviewing video and seeing the incident, I do think it would be necessary to have it.
Mr. Todd, if your clients want to go forward today, we'll go forward, but I must be honest with you. I'm not going to have fronts open up in all locations as it relates to this incident. I'm going to let law enforcement do their investigation, let the district attorney's office make whatever decisions that they choose to make. I haven't heard the evidence now, but I really would like to know or hear from this officer. But if I proceed today, I'm going to be proceeding on the assumption that the officer has investigated and decided to not arrest Mr. Clark.
And I have a few minutes to speak with my client and then I can let the court know.
Yes, sir.
Thank you.
Yes, sir. Okay, let's bring up Miss May Gardzendine.
Yes, Your Honor. Ms. May, she's coming now, Your Honor.
Okay.
Have a seat, Ms. Chair.
Good morning, Your Honor.
Good morning. I'm going to ask you a couple questions about the position 3. Is the person's name Cedric or Cedrice Moten?
Cedric. Cedric.
Okay, that's what's written on the application, but on my calendar, it's written as Cedrice. And the allegation in this case is that he bought a car from Atlanta Fine Cars and drove the car to Alabama to change the registration on the vehicle.
Yes, sir.
Why would jurisdiction be appropriate in Clayton County?
Because that's where he purchased the car from. And
But it appears,
he did the fake paperwork in Georgia.
I understand, but it appears that the act that you would be seeking the warrant for occurred in Alabama.
Okay, if you look at the paperwork, I'm not sure if you have a copy of the title from Alabama. It's
So ma'am, the first thing the court has to do is to look into its own jurisdiction, whether
okay.
it has the power to listen to evidence about this. I understand the car was purchased in Clayton County, but it was driven out of state. The vehicle registration was apparently changed, which is a crime that occurred in Alabama. and then the car was sold to CarMax.
Yes, but the problem, the car was sold to CarMax here. So probably he just have an address in Alabama, but the person he sold the car to here is a Georgia resident.
Was it a
CarMax-
crime? Was it a crime to buy the car in Clayton County?
Say it again, sir?
Was it a crime to purchase the car in Clayton County?
No, it wasn't a crime.
So the alleged criminal conduct occurred outside of Clayton County.
Okay,
So I can't issue a warrant for conduct that occurred in another jurisdiction.
okay.
So do you have proof other than the vehicle being purchased in Clayton County that a crime occurred that I could issue a warrant for the person's arrest in Clayton County?
Not at this moment. I know we sent out the certified letter to the Georgia address, but it has not come back yet. And I'm not sure if the court already sent out their letter for them to
Have
come
you-
to court.
Have you sought help from law enforcement? Either the Attorney General's office or the county in Alabama where the car was registered?
No, not in Alabama, but here, actually, I just did the class for the renewal of the license, and where it was found out that they have people, and this is not the first actually, where they take the cars to Alabama and do abandonment stuff, and they have two other ladies within the Alabama DMV that helps the customer to do that. And that's why I even have the Georgia title, but at this moment it's actually being voided because there's an Alabama title out there.
Which I see it all the time. North Carolina, Tennessee, wherever people have people that they know that they work in a certain location. If the person is caught with the vehicle here in Clayton County with an altered VIN, the person can be arrested here. But the allegation that you're making is that the person purchased the vehicle from your establishment and took it somewhere else and committed a criminal act wherever they got the registration changed.
I understand what you're saying.
You said you do not?
I do understand.
Okay. So this doesn't mean that a crime has not been committed, but it's going to have to go either through the location, the county in Alabama where the car was re-registered. That could be either local authorities there, the Georgia state attorney here can prosecute this case, or the FBI can prosecute the case. But I think that the first thing you have to do or should do is contact one of those law enforcement agencies to make a report of what happened so that they can then pursue it the way that they would normally pursue it.
Yes, sir.
Okay, so I'm gonna dismiss this case for want of jurisdiction. Now, my understanding is that you may want to have an opportunity to speak to the accused, Mr. Williams, in the other case.
Yes, sir.
Is Mr. Williams available?
Yes, Your Honor. Your Honor, if I may, if I can put the plaintiff in the other room and bring Mr. Williams to the front?
Yes.
Okay. Mr. Williams, come forward, sir. Follow me, ma'am. Your Honor, Mr. Williams is approaching.
you doing, John?
Mr. Williams, you heard that the plaintiff wants to have a discussion with you. You're not required to speak to her, but it is always best to negotiate matters rather than to place it in the court's hands. Are you willing to have maybe a 5-minute discussion with her?
Yes, sir.
Okay, what I'm going to do is I'm going to place the two of you in a breakout room. And I'm going to take about a 5-minute break to allow the two of you to speak. And if you can reach a resolution, that's great. If not, we'll go forward. Okay, you both should be in breakout room number 1 now. Mr. Hutchison, can you assist them in hitting the link to be placed in a breakout room?
Yes, sir. I'm about to do it now.
Okay, so I'm gonna give you 5 minutes and I'm gonna take a break. And then I'm gonna open the room up and I'm gonna hear what agreement, if any, you may have reached.
Okay.
All right. So